Does a will need to be notarized? Have you ever wondered if a will needs to be notarized to be valid? This question is quite common, especially for those planning their estates. Let's break down the facts surrounding this topic. In most places, a will does not requiring notarization to be legally valid. The key requirement is that the person making the will, known as the testator, must sign it. Additionally, at least 2 witnesses who are not beneficiaries must also sign the document. This process helps ensure that the will reflects the true intentions of the testator and that they were of sound mind when signing. However, there are a few exceptions to this general rule. For example, Louisiana is unique in that it requires notarization for a will to be valid. In all other states, notarization is not mandatory, but it may be allowed or even recommended. One of the benefits of notarizing a will is the opportunity to include a self-proving affidavit. This is a notarized statement signed by the witnesses confirming that the will was properly signed and witnessed. Including this affidavit can simplify the probate process, as it reduces the need for witnesses to testify in court about the will's authenticity. While notarization is optional in many states, it can make a will more enforceable and less likely to face challenges. It serves as additional proof that the will was executed correctly and that the testator was competent. However, it is important to follow the specific laws of your state regarding notarization, as improper notarization could potentially invalidate the will. In Canada, the rules are similar. A will does not need to be notarized to be valid. Instead, an affidavit of execution, which is a notarized statement by a witness confirming the proper signing of the will, is often required during probate in most provinces, except British Columbia. From the perspective of elder law and estate planning, while notarization is not a strict requirement, adding a notarized self-proving affidavit can help protect the testator's intentions. This can be particularly important in cases where the will might be contested due to questions about the testator's mental capacity or undue influence. So, while notarization is not universally required for wills, it can be a smart step to strengthen the will's validity and streamline the estate administration process. Always be sure to comply with the laws of your jurisdiction and consider notarization as a way to minimize potential disputes and challenges.